That's why we've decided to call this the last webinar. And we're going to be talking about POPIA, also known as the Protection of Personal Information Act. And we've got an industry expert joining us. Denise, are you there? Hello. Just unmute yourself, Denise, if you don't mind.
Yeah.
There we go. How are you?
I'm very well, thanks. And how are you, Justin?
I'm well, thank you. Thank you so much for joining us and being part of this initiative. I don't think you need any further introduction. You know, I think most people here know you very well as being part of the industry for many years. So it'd be great to get your knowledge and to chat about an important topic. So guys, I think the way that we're going to kick off, we've got a little presentation going. We're just going to kick off perhaps just with a brief introduction of what POPIA is, perhaps why it's important. And then what we'll do is we'll move into the consequences of not adhering to this act. I think it's important to actually cover that. And then what we'll also do is we'll then have a look at the 8 conditions that the Act sets out and which we've got to adhere to. And then we'll see how that actually affects the debt review industry. And then we'll move on to some of the solutions that we think we can have. So we've kicked off with a little poll in the beginning. It'll be quite interesting to see what you guys sort of think of, are you POPIA compliant at this stage? And perhaps after the seminar, we can then have another poll at the end and then see if any of the views differ. So we'll take it from there. All right, so I'm going to kick off why is it important and what is POPIA? So guys, really the POPIA, as I mentioned, is the Protection of Personal Information Act, and it's South Africa's data protection law. So I've literally just included the sort of preamble that's part of the act that puts out what this act really is. And so just to go through that, so that I think, it's important for us to sort of understand where we're coming from, why it's important, so we sort of know what our end goal is. So again, what does it do? It aims to promote the protection of personal information. And this is important because it's processed by public and private bodies. So it's both those bodies that have to adhere to this. And then there's obviously certain conditions, and there's 8 conditions, which we'll talk to a little bit later on within the presentation. That's sort of establishes the minimum requirements for the processing of personal information, which we all have to adhere to. There's an information regulator that's been established, and that person's going to be responsible to perform certain duties, powers, and functions in terms of this act. There's some codes of conduct on there, and also it just provides the rights for persons with regard to unsolicited electronic communications. And then again, it also deals with the flow of information cross-border. So I think, and Denise, maybe you can also just speak to this. For me, I think sort of why this act was put in place was, there's a lot of personal information being used by parties to commit fraud and unlawfully obtained, number one. And number two, I think people were just fed up of receiving unsolicited communication because they obtained information from a third party that they didn't consent to. I don't know if you also agree to that, if that's sort of the importance or the basis as to why this act was put forward.
Yes, absolutely. So, the thing was that as we move into a more digitized world, more of our information is out there. And the more that your information is out there, the more at risk you are for all sorts of things, cybercrime, fraud, but even scarier crimes, because your information is just so readily available, and there's so many public platforms and that kind of stuff. And I think that's why, this POPIA Act is very important. And I think also that there is a strong governmental will to enforce it for the protection
100%.
of their people.
100%, yeah. And we're actually going to talk about this implementation and sort of the consequences to that. I think it's also important to note that, all processing of this personal information has got to confirm within a certain time period. So even though the commencement of the act has happened on the 1st of July 2020, there was a 12-month grace period given, which ends in, I think, no less than 7 months. Do you think that's enough time for people to get stuff ready? I think it is, if we start doing something now, Denise, if you agree with that.
I think it's difficult. I think that, there are solutions out there, but I think we need to look very quickly for solutions as an industry that work for everybody. Yes. And I'm going 100%. To give an example. Yes. Everybody here is required to submit information to the NTR. So where are we then? Because
Correct.
We are obligated to do it, but there is a problem with us transmitting that information, and I don't know when or how they would be ready to receive, say, for instance, encrypted.
Yes,
So I think
yes.
it's tough. I do know that the NCR is speaking to the information regulator to get, some sort of leniency for the debt review industry as a whole.
Industry specifically, okay.
Yes. But yeah, so I think it's going to be tough because not all the industry participants are at the same level. And
Yes,
it doesn't do anybody any good if 80% of debt counselors or 80% of credit providers are able to be compliant, but not everybody is, because I still have to interact with non-compliant people.
With those non-compliant ones, yeah, 100%.
Exactly.
Yeah. So guys, I think what we also just need to do is, and we need to just spend some time here, is just to look at the 8 processing conditions, because this is really the crux of what POPIA set out and what is needed and what needs to be adhered to. So if we look at the first condition, which is accountability, so there we're obviously dealing with a responsible party that needs to ensure that the conditions that the Act sets out are actually met and that they are complied with. So there's a number of questions that we need to take away from here to say, well, who's going to be tasked with this within your organization? There's got to be somebody that's going to be tasked with this. And this individual is ultimately going to be held liable for any non-compliance in those certain situations. And again, how is this person going to ensure that you are POPIA compliant? Is it policies? Is it procedures that need to be put in place? So I think it's an important aspect that needs to be to be given thought now, that there is somebody that is going to need to sort of take charge of this within your organization. And they're ultimately going to be responsible to ensure, okay, are the policies covered? Do you have the correct wording in your consents that you send through to your consumer or to the data subject when you obtain it, so that they are fully aware in terms of the other conditions, what they are agreeing to and what they are consenting to. So I think that's an important note for us to take away from the accountability aspect. Moving on to condition 2, so process limitation. So again here, it's the personal information can only be processed in a fair and lawful manner, and only with the consent of the data subject. So I think what's important here is this person that you're getting the information from, that person needs to consent to it. The person's got to be aware that you are also gathering this information and that they are agreeing to that. And I think that's, one of the most important crux of this is to say, look, consumers need to be aware what the information is being used for and that they have agreed to it. Would you agree with me on that, Denise? That being one of the most important aspects of these conditions.
Yes. So,
okay.
So the big thing is letting the person know, because it's not so much that you're going to get their information. It's that as a debt counselor, you would share that information, for instance, with the PDA or with the NCR.
NCR,
So, and you would be obtaining information that you didn't get directly from the client, but from the credit providers. And sometimes I don't think the full scope of how much information the debt counseling process has and shares is evident to clients, and they have to know. They absolutely have to know.
Okay, so I think that's important. And you know where this comes in? This comes in with condition 1, which is the accountability. The person who is accountable for this needs to make sure that the wording in the documents that get sent to the consumer, that they sign through, that they know exactly what information they are giving through, what the information is going to be used for, and more importantly, who it's going to be shared with. I think if we move on to condition 3, which is the purpose specification, again here, this also ties in with condition 2, is the information needs to be used for a specific purpose, and it has to be explicitly defined, and there's got to be legitimate reasons behind that. So what we need to take away from here is to say, look, is the person aware what they are using the data for? So I may agree to give you my data, yes, but do I actually understand, have I been told that my information is going to be used, like you're saying, Denise, it's going to be used to be sent to the credit provider because of X. It's going to be sent to the NCR because of X. So I think condition 2 and condition 3 sort of work together, because one is the consent, but also what am I consenting to? What is the reason? What are you going to do with the actual data that I actually send to? Guys, condition 4, so further processing. So again, these are sort of all intertwined because you're dealing with personal information that can't be used for a secondary purpose. So, I may get a consent from a consumer to that they agree that I can take their personal information and use it for X. But is it important, or I think what is important that we should note is to say, okay, can I use it for another purpose, for a secondary purpose? If it's compatible with the original purpose, yes, I can. But I can't use it for a completely different purpose just simply because I have that information available. And I think that's important for I think debt counselors and people to make aware of. And that's why it works together with condition 2 and condition 3 is to say, I consent to it. I know what you are doing with it. And also, if there's any additional things outside of that original scope, I'm going to have to get a further consent from that consumer so that they are aware exactly where the information is being passed to and for what purpose. So I think it's very important that those 3 conditions work together as a whole, because that encompasses what the data is being used for that is being sent. Condition 5, information quality. I think this is also important just simply because, there's got to be a responsible party that needs to take reasonable steps to ensure that the information that they get is complete and accurate and not misleading. I think there's a lot of information out there that isn't always necessarily updated, as an example. So I think we've all got to know that the information that we receive, is it reliable and is it actually accurate? And we've got to give the consumer or the data, the person who you get the data from, the opportunity or the avenue, I think is the right word, for them to update their information, number 1. And number 2, if they want to withdraw their consent, they have the right to do that as well at any time. So we've got to make that available to them as well. Guys, I'm going to go on to condition number 6, which deals with openness, which I think also, again, deals with a lot of these things together. But the data subject whose information that you are collecting it from must be aware that you are collecting it. That's such personal information for the purpose and for the information to be used. So again, this is the consumer, in this case, understanding what their information is being used for. And this is where there needs to be disclosure. And you'd agree with me, I think, Denise, is that there's got to be I think the documentation that's being sent to the actual consumer by the debt counselor needs to contain, I think, a lot more clauses and disclaimers in there that makes them available or that makes them aware of where their data is going, why. They've just got to be open about the whole subject so that consumers know exactly what they are giving their data for and who it's going to be shared to. I don't know if you can comment on that aspect specifically.
Yes, and the other thing that we have to have in there is a client's rights in terms of the act. So what you would need to specify is not only what you are using the data for and who you would send it to and where you would get data from. These are very important aspects, but you also need to tell your clients what their rights are and what they can do. So in terms of the act, of course, they are able to request any information that is held about them. So they could come to you and request it. Alternatively, they could go to the credit provider or the NCR and say, what information has my debt counselor provided to you? And they could check the accuracy of that. It is up to the person dealing with the client's data to make them aware of their rights in terms of POPIA.
Yeah. I think that is very important, 100%. Guys, and then I also think where we also going to get stuck as a whole industry are the security safeguards. I think that's one of the most important conditions here. It's the personal information that you've now obtained. So you've obtained it legally, the consumer's consented to it, they know what it's being used for, great. But this information needs to be kept secure against any form of loss or unlawful access, interference, modification, etc. And I think what's important here, I mean, there are so many questions we can ask here, is to say, how do you, as an internal body, how do you store that data? Is it encrypted? Is it password protected? Who within your organization has access to these, to the consumer's information that they can perhaps share it on to other third parties like they shouldn't? And then again, you have the whole topic of, well, how is the data transmitted? So when the debt counselor sends the 17.1 to the credit provider, how is that being transmitted? When the credit provider receives it, how is that party, again, saving the information on their side, making sure that it's not open to being logged into, stolen, accessed, And then again, when the credit provider sends information back to the debt counsel in the form of the proposal response or in the form of the COB, again, how is that transmitted so that it's not intercepted? Because let's face it, Denise, at the end of the day, there is so much information that we get from debt counselors that's got personal information on. You know, when we're dealing with proposals, you've got payslip information, income and expenditure. There's a lot of personal information on there. And if that's intercepted, you know, that can be used against them. I don't know if you want to comment on that one specifically, because that is quite a big condition that I think as an industry we're going to battle with to you know, try and get right within the time frame.
Yeah, I think that's one of the biggest issues. So when we've got the responsible party, so a responsible party in any transaction, so you have a responsible person within your organization who's responsible for your POPIA sort of adherence, but the responsible party in any transaction changes as the transaction goes along. So when I am sending information to another person that entails my client's personal information, I am the responsible party.
Sure.
When somebody else is sending information, so they need to make sure that it's secured, that the transmission is secured, and that the person they're sending it to is entitled to receive that information, right? So that makes you the responsible party generally when you're sending it. But when it comes to debt review, it's actually slightly different. So on receipt of a 17.1, by law, a credit provider has to give certain information.
Correct.
Right? So it means that even though I'm transmitting the information, I am not the responsible party in that particular circumstance. The debt counselor is, because I have no way or legal way of checking to see if they're entitled to that. I have to act on the 17.1.
You have to act on the 17.1.
Right. So I don't get to check the form 16 that the client knows and all the rest of it. When we receive a 17.1, we need to act on it. So I give all the COB information, ID numbers, account numbers, balances,
everything
goes to the debt counselor. If the debt counselor is not entitled to that, the debt counselor in that situation remains the responsible party, because
it is a very difficult one.
And I think that debt counselors must just be aware that sometimes when they're asking for information, really the one sending the information. And that's a slightly different nuance that is really specific to the debt review industry and some other sort of legal processes. But it's an interesting one.
It is an interesting one. Yeah, I agree. So I think what debt counselors need to take away from this specifically is that at the end of the day, they are responsible to get the necessary consent and requirements from their consumer, from their data subject. So like you're saying, Denise, if we are responding on that in terms of the act that says, I've got to supply X and I supply X, if you weren't entitled to that in the first place, that's not something the credit provider can be held liable for. So a debt counselor can't wash their hands and say, well, you should have known not to have sent it to me. It's actually the debt counselor that's going to have to take responsibility for it. So that's a great thing to speak to. Thanks about that, Denise. Okay, guys, condition 8. So I think this just gives the data subject, and again, it's a very clinical name for just the person that you're getting, that the data refers to, or that the personal information refers to, is that they may request whether their personal information is held, as well as the correctness and or deletion of their personal information. And this is where Denise spoke about it earlier, where she said, you know, the consumer has the right to contact the NCR and say, what information has been given to you? And they will advise the consumer thereof, and they're fully within their right to say, actually, I need you to delete that. I don't want you to have that information. And that's why it's crucial that debt counselors at inception, right at the beginning of their process, that their documentation is drafted and the discussions that you have with your consumer as well, that you make them aware that your information, yes, you may agree that you are giving me the information, but who is it going to be sent to? And there are a lot of third parties that we'll speak to a little bit later on in the presentation that people may not necessarily think, do I need to tell the consumer that I'm sending to the NCR? Yes, you actually do, because it's a third party. Okay, guys, so those are the 8 processing conditions, and we're going to see how this sort of fits within the debt review process shortly. But I think it's important just for us to have a look at the consequences of non-compliance. So the Act makes provisions for fines as well as jail sentence. So fines of up to 10 million rand and jail sentence of up to 10 years. So obviously it depends on the seriousness of the breach. But as you can see, Section 107 of that Act sets out what those offenses are. So guys, it is quite severe. And it's something that we need to just make sure that your I's are dotted, your T's are crossed, so that you're not in a position where if you're being investigated, that you're going to be up for this, for either a fine, a jail sentence, and or a combination of both of them. It's really something that I think people just need to take into consideration. You're not just going to get slapped with a 5,000 rand fine or anything like that. It is quite severe on what can actually happen. So guys, how does this apply to debt review? I think this is what's important. So I did a little sort of, just a little infograph here as you see. So you have your 8 processing conditions here. You have your accountability, you have your processing limitation, the specific purpose and what you're using it for. Can you use it for any other additional purpose? The quality of the information that you have, the openness, the security safeguards, and the data subject participation. And all of these 8 processing conditions need to apply to each of the parties. So you've obviously got the consumer, who is the data subject. That's the information that we are getting from, and it's the consumer's information. The debt counselor's got to ensure that all 8 of these processing conditions are met when they obtain this information. Again, the credit provider has also got to ensure that the 8 processing conditions are taken into account, as well as the third parties. Because remember, there's the PDA, there's the NCR, there are attorneys that you perhaps give the information to. They themselves also have to take responsibility on ensuring that they also make sure that the 8 processing conditions are taken in. I don't know if there's anything further that you want to maybe comment on this, Denise. It is quite self-explanatory, but I think it would be nice to get your viewpoint on that.
Yeah, I think that we need to just think about the debt review industry, and what I would like to caution debt counselors about is life insurance and that kind of stuff, 100%. Any kind of credit life insurance. So remember, if you are somebody who is contracted either for yourself or if you refer leads, you must tell the client that you're going to do so. So that's one of the nuances. So you can do it, but you need to make sure that the client knows about it. So make sure that your contracts cover that and that the client consents to you giving the lead to the insurer or whatever. That's number 1. And then number 2 is, what was the other one that I was saying? Oh, yes. If you are a debt counselor who gets leads, wherever you get your leads from, you need to make sure that where you're getting your leads from is POPIA compliant, and that the client has consented to their information being shared with you. If you are caught with information that you are not entitled to, like for instance, that can sometimes happen with the buying of leads, that will be a big problem. That's when you start getting those big fines. A data breach here or there every once in a while, I don't think is what they're looking at. But I think buying people's personal information without that person's knowledge is a big problem. And we do know within the debt review industry, I mean, everybody's got to get business from somewhere. So I think we must just be cognizant of it to say, what is my business process looks like? Where am I getting my information from? And am I okay to have that information? Is whatever party I'm getting the information from, are they doing the right thing so that I don't get into trouble?
Sure. Denise, do you think that the debt counselor needs to go one step further? They may ask the question and the party that they're getting the information from says, yes, of course, they have agreed. Is there an obligation on the debt counselor to go one further and say, well, show me a document where the consumer has signed and actually agreed to it, or a voice recording or whatever it is? Is there that sort of one further step that a debt counselor needs to make?
It's probably not necessary for a one further step for each matter, but definitely the debt counselor needs to be comfortable that the place where they're getting their information from has the process in place, so a standard contract or a standard voice message or whatever that says, yes, I consent to, They absolutely have to be sure. So you don't have to check for each individual client. That then causes more work. But you need to be comfortable that the place where you are getting your information, you are comfortable that they have processes in place that are POPIA compliant.
Okay, great. Okay, guys, so that's what you need to do on your side. Just make sure that the information that you have obtained is POPIA compliant, and I think that's the most important aspect. So, guys, how does the supply to debt review within each of these spaces? So, I have taken sort of third parties out of this. I know we have discussed this in the previous slide. So if we look at the consumer, what happens? The consumer approaches you, he applies for debt review, and he issues you with a mandate to say, yes, I'm happy for you to do that. What do you need to do as a debt counselor? So you have to act in accordance with the Act, and that's in accordance with the POPIA Act, it's in accordance with the NCA. There's various legislation that you need to comply with, as well as the mandate that the consumer is giving you on. So again, in your Form 16, again, it's got to contain the proper consent. And I've included all of these 8 conditions on here. And this doesn't necessarily inform to the COB stage and the court stage and the proposal stage. It's encompassing of the entire process. So at the inception of debt review, in terms of the Form 16, which, like Denise mentioned, as a credit provider, we don't have view of that. So you've got to ensure that you've got the necessary information and the consent from the consumer. And you do that by having a proper consent. You have the proper purpose listed there. You mention the processing. You mention the information quality. You've ensured that the information is correct. So you haven't just relied on the ID number. You've obtained a copy of the ID, that sort of thing. And there's been openness where you've advised the consumer exactly what that consumer can expect throughout the debt review process. Now, that should be happening now as it is. But I think we need to go one step further here to say, look, I'm going to be sending your data to the NCR. I am going to, once I've uploaded the data to the debt help system, your account is going to be flagged on the bureau. I have to send your information to a credit provider. So they are going to know exactly what your income, what your expenses are, what your living expenses are, etc. They've just got to be aware of it. You've just got to make the consumer aware of it, and they've just got to agree and say, yes, I'm happy that you use the information, and I'm happy that you send the information to these third parties, including the attorneys as well, including your insurance guys as well, so that it's all on paper, so that you don't have any questions that you need to perhaps battle with if you do get a question from the information regulator. So again, you have to confirm with the consumers all purpose for which the information is collected. So again, you can't use the information for another third reason. It's got to be specific to what you're actually telling the consumer it's actually for. Again, all documents sent to the credit provider needs to be protected. And, Denise and I have spoken to that, where we've got to look and say, okay, we may be sending data through to the credit provider, but there is going to be a responsibility on you when we send the data back that you actually are entitled to that information. How we send it back, we'll chat about it in our sort of solutions section. I think guidelines provided to the consumer of the right to request correction of information, I think they need to know that they do have that right available to them, that if they come across information that is incorrect, what are the avenues for them to take in order for them to correct the information or question the information. Protection and storage data, we have spoken to that. So again, you are going to have all the personal information from your consumer. How do you save it on your side? Do you have physical files that you leave around in the office? That's going to have to be re-looked at. If you're saving it on the cloud, is it secure? Is it encrypted? Can anybody within your office walk in and download a consumer's file and have all the personal information? I think all of that needs to be taken into account. I don't know if there's anything else you want to maybe mention there as well, Denise, or if we've covered sort of anything from a debt counselor perspective.
No, I think you covered all of that.
Okay, perfect. Then guys, obviously the credit provider, we've also got to adhere to those eight conditions. And again, we've got to comply with, Section 86 and Regulation 24. And that's where Denise mentioned earlier, is to say, I'm getting an instruction from you where you are telling me that you need the COB. And in terms of the Act, when I get that instruction, I've got to act on it. So again, there is some nuances there that we have to look at. Again, we've also got to ensure that the credit provider, when they receive the information from the debt counselor, that's also kept securely. It's not being, you have IDs being printed and information proposals being printed and lying all over the desks. That's obviously got to be taken into account. And all documents that we provide, we've also got to ensure that the processing is done properly, that it's being transmitted in a correct manner. And I think where Denise also mentioned a very good point is to say, you know what, it's great if 80% of the people are compliant. How do I transmit documents to the other 20% that aren't compliant? You know, how do I actually deal with that? So that's something that we're going to have to come up with the actual, you know, when it comes to looking at the act and how we're going to comply to that. So guys, solutions, what are our solutions? So I've just jotted down 4 here. You know, there's got to be SOP enhancements to technological advantage to protect the data storage. So you've just got to relook at how you're protecting your data. You can't just necessarily save it on a hard drive and keep the hard drive on your desk, for example. There's going to be different ways in which you do that. You've obviously got portal accessibility. So there, again, we speak to DREX. We've got that facility where, you know, data can be transferred via the portal so that it's not sent via email. You're looking at password protections and encryptions. And then again, when it comes to debt counselors specifically, the standard documentation for consumers to sign so that they are aware of all 8 of those processing conditions, that they've agreed to the information being sent to you. They know what it's being used for. They know that it can only be used for a specific purpose. You've been open to them on the whole process of where it will be used, who it will be sent to, how it will be stored, their rights to question what information you have, and the right for them to retract that. That all needs to be encompassed in your disclosures, in your disclaimers that you have within your contracts. I don't know if there's anything else you want to perhaps add onto there, Denise, on perhaps solutions that we can come up with to try and just make this process a little bit easier within the industry.
Yeah, like I said, you know, the problem with the industry is we're only as strong as our weakest link.
Yeah.
You know, if we can encrypt files and send it out, that's fine.
That's
if
fine,
the person on the other side is not able to open it, then it's pointless.
Then it's pointless.
And you know, and so yeah, so that's one of the things that I think we're grappling with as an industry. And like I said, you know, one of the biggest issues is the NCR is not equipped to deal with encryption or non-encryption and that kind of stuff. And we're all sending stuff to them, right? The PDAs are submitting all sorts of files. We're submitting all sorts of files. There's a whole bunch of stuff that's going on. But also, I mean, the guys on the lower end, micro lenders, you know, from the credit provider's perspective, how many of the micro lenders are going to be able to encrypt files to send to a debt counselor, or receive encrypted files from a debt counselor? So we've all got, you know, each of the parties has limitations, because as a credit provider, I need to come up with a solution that can cater for all debt counselors, because by law I have to be able to communicate with them. And so this is one of the difficulties that we're facing within the industry as a whole. I wouldn't say that's an excuse. I think we definitely absolutely have to do what we can do now, you know, so that even if we only solve for the 80%, that's fine to say, well, 80% of us can sort of, you know, communicate with each other and send this very, very dangerous information, you know, but we can protect it in some way. So that's one of the things. The other thing, the standard documentation over there is whatever documentation you do as a debt counselor, please, there is personal information and then there's special personal information. And there is a list, and I can't remember off the top of my head, you know, when I left the other place, they wouldn't let me take my stuff with me. I had to leave it behind. So all my research and stuff, years and years of stuff, of papers and stuff that I've done, I sort of had to leave behind.
Yes.
But so I can't remember off the top of my head all the special personal information. But sexual preference is one of them. So whatever form you have or anything like that, I know we don't ask that, but still.
Yes.
Information regarding minors. If your form asks for kids' information, please take it out. What you need to know is that I have 2 kids and what their ages are. No names, no ID numbers, no nothing. Health information. Now, a lot of debt counselors, we do sometimes need health information, medical information, because...
Medical information, yes.
Right. A client has a big, you know, a big medical aid or lots of additional doctor's bills. We would need to ask for that kind of stuff. But guys, that kind of information is like the Holy Grail. Don't lose it. don't let anybody have access to it. It is exceptionally confidential. And like I said, it falls into a subcategory of personal information. There's personal information, which is your income, age, sex, ID number, you know, blah, 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 all that other kind of stuff. That's your personal information. And then you have the special personal information.
Special.
And that is, it is important that you guys know what it is so that you don't by accident ask for it. And it's considered to be information that there is, even if you follow all your 8 conditioning steps, processing conditions, it doesn't protect you if you're using that information. Okay, so we just need to be sure what information we have, what we're using, and we need to be very, very careful about some of the information that we have.
Okay, great. Thanks for that update, Denise. Thanks. That's great. So I think most debt counsellors, like you're saying, don't necessarily go on to what is your religious beliefs and things like that. But I think, you know, you may just find that there are standard documentation on there. And you know what us attorneys do? We put every conceivable option on a document just to protect yourself. So you may just need to look at some of the information on there to say, look, I need to take out this line or take out this line. Because like Denise says, even though you're storing it and you're keeping it, you're not necessarily entitled to that information. So thanks for that. Look, that's the end of the webinar. So I'm going to switch it off now. But I think what's definitely needed here, Denise, is I think there needs to be some further discussion. I think within the first quarter of next year, you know, I think we need to touch base perhaps with the NCR, with VASA, with the other retailers, with the CASA and all the other debt counselling associations as well. So you see, look, we're fast approaching. Yes, we're 7 months away now. In Jan, we're going to be 6 months away, and then it's going to be 5 and 4. And before we know it, we're going to have to do things that we haven't actually looked at to see how it can resolve. So I think there's definitely more information that we need out there. I know from our last discussion with the CASA, they did mention that there was no information back from the information regulator when the NCR did sort of propose things through. So we're going to have to wait and see if that comes through. And if it doesn't, what do we then do? You know, we've obviously got to come up with a solution because, like you say, we can't just say, well, sorry, we can't do anything. You know, you're still going to be accountable at the end of the day. So guys, we've done another poll. So it's just post our discussion we've had today. Has it changed? Do you still think you are? Are you still unsure? Is it not? So I'm going to let that run for a bit. It'll be interesting to see what the 2 polls show post this conversation. But Bernice, again, thank you so much for your insight here. It's been greatly appreciated. And I'm sure we would love to have you on board in the new year at some point. When I think we have a sort of version 2 POPI discussion with the actual industry. And hopefully we'll have, like you say, the NCR on board. Because I think, you know, like you mentioned, we need to get some information from them because you're saying we're only as strong as our weakest link. And if the NCR themselves perhaps aren't at the stage where they are able to run out with us, then, yeah, we need some information from them as well. So I'm going to just give this a couple more seconds and then I'm going
There's
to
some Q&As. There's some questions on the thingy.
Yes, there are a couple. I see most of them are from our resident magazine
Zach,
expert,
really?
Zach. So what we will do is, what I'll do is, Zach, and I think there are a couple of other people. I know some of them we have actually answered. But what we will do is I'll circulate the questions to Denise as well, and we can put a little sort of Q&A spreadsheet together, and then we'll send that off to all the participants here, just so that we've looked at each of those of the questions and we've applied our mind to it, and we've been able to actually answer it. So we'll do that by the end of the week, if not the beginning of next week. So I'm going to end this poll now, and then I'm going to have a look at so there's the results. I'm just going to have a look at our first poll. So our first poll when we started, let me just stop the poll, and then I'm just going to quickly, give me 1 second while I navigate here. So the first one, okay, so when we started this, 43% said yes, you believe that you are POPIA compliant. If you are sending an email to me with an attachment and no password, you are not POPIA compliant. I'm just putting it out there. 10% said no, and a very big 48% said that they're unsure. And you know what, fair enough. I know that there's a lot of things to look at. If we look at, and I'm just going to share those results again, just for guys just to take a screenshot or a picture of it. So that was the results right at the beginning. And then what I'm going to do is I'm going to show you the second poll. And yes, there is a marked difference. So again, 30% saying yes, 37% are now saying no, that they are not. And I think that sort of deals with the whole email issue, the transferring of documents, even something as simple as saving a document on your desktop and not the proper way, you know. And then your 33%, which are still unsure. So I think what this shows is that there's definitely a need within the industry for us to re-engage within the first quarter of next year, see if we've perhaps received information back from the info regulator, whether it's a commentary or a meeting or something of some kind. You know, perhaps they will agree to expand on certain of the definitions in there. And then perhaps it may be pertinent for us to relook at having a webinar with all parties on board, so we sort of know by sort of, you know, February, March, where we stand and what we need to do. Did I share these results? Yes, I'm going to share it now quickly, so you can take a screenshot or a photo of that. All right, guys, so that brings us to the end. I just want to see if there were one or two more questions that came through. Okay, so I will get these all through to Denise, and then we can just have a sort of round robin chat quickly, and then we'll transmit all those answers through to you. Denise, thanks so much for joining us. Always a pleasure. We haven't spoken since forever, since the pandemic happened. But is there any last comments you want to say on your side?
Yeah, I just want to say thank you very much for
Sure.
the invite. Hi,
Of
guys.
course.
Nice to chat to you again. You will see that I'm like a lot more casual in my appearance these days because I never leave the house.
I think everybody is.
So yeah, but thank you very much for the opportunity,
Cool.
Justin. I appreciate it, and I hope it was valuable to the guys on the line. And yeah, we'll chat again.
Cool. Thank you so much, Denise, and thanks everybody again. I encourage you guys just to keep track. Just, you know, have a look at our social media. We do have a you know, a page on our actual web page where all the videos are on, and there's some nice industry information there as well. We also have a LinkedIn page which we're trying to keep up to date as well. So just follow that, and at least then if you weren't able to join, you can always share the video with other dead counselors. I think it's important for people to see this and people to get involved in it. And I think the more information you sort of give out to people, I think the better the industry is going to be. We've come a very far away from the dark ages of a dead review where we wouldn't be seen in a room together. And now, unfortunately, we cannot be in a room together because of the pandemic, but at least we've got these sort of avenues available for us. So again, Denise, thank you so much. I appreciate your time and your effort. And to all the dead counselors out there, thank you so much. It's been an interesting year. And like I mentioned, this has been the last webinar for the series, and we'll kick it off next year. We'll probably do a little round robin email to everybody to find out what other industry questions or topics you want to discuss. And then we will have the people on board. So again, thanks again from our side, and we will chat soon. Please be safe. Have an awesome festive season. Please be careful out there. Don't get lax because we can buy alcohol on the weekend now. Please just be aware that you guys still need to be safe. You still need to look after yourselves so that at least we can all be in touch during the course of next year. All right, guys, be safe, and we'll chat soon. Bye.